everyone, good evening and welcome to Thorough Newspaper Analysis. Now this is the video for the 26th of June 2024. Now let's proceed and have a look at the pointers of discussion for today. So here essentially we talk about the agenda. So first of all, we have the editorial segment, and here for today's discussion, we've taken up an Indian Express article. Now this article, it is about a law which is prevalent in Jammu and Kashmir. We'll understand what are some of its provisions, why is this particular law in news recently, and why is this law very stringent, even more stricter than the laws like the UAPA, which is considered to be very strict law in itself. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news, where today I believe we have 3 or 4 legal news to come. So without further ado, let's start with the article and let's first have a look at the title of it. So what is the Enemy Agents Ordinance, tough law applicable in Jammu and Kashmir? So from the heading itself, we have, we can infer that we're going to talk about this particular law called the Enemy Agents Ordinance. So let's see the context recently, in light of which the discussion around this law, it has come to the forefront. So see, recently the DGP, the Director General of Police for Jammu and Kashmir, he said that those who are found assisting militants in Jammu and Kashmir, they should be tried by investigating agencies under the Enemy Agents Ordinance of 2005. This law, it is stringent, more strict, more harsh than UAPA, which is the Unlawful Activities Prevention Act, and it has punishment which can go up to life imprisonment or as severe as the death sentence. Now let's understand what is this ordinance and why is it called an ordinance instead of being called, let's say, an act. So the Jammu and Kashmir Enemy Agents Ordinance, it was first issued way back in 1917, and this was done by the then Dogra Maharaj of Jammu and Kashmir. It is referred to as an ordinance since laws which were made during the Dogra rule, they were called the ordinances, and hence the name ordinance. This ordinance, it states that anyone who is acting as an enemy agent or anybody who's conspiring to aid the enemy or somebody who is hindering Indian military operations or endangered lives through actions like arson, they face severe penalties. So that is the core of this law, that whoever, who is indulging in any of these sort of activities, they are liable to face severe penalties. Now let's talk about the punishment structure. So punishments include death, life imprisonment, or rigorous imprisonment for a term which can range up to 10 years. After partition in 1947, this particular ordinance, it was incorporated as a law in the erstwhile state of Jammu and Kashmir and was also amended. But as we all know, in 2019, a very major change took place so far as the status of Jammu and Kashmir is concerned. That is the Reorganization Act of Jammu of 2019, and also the abrogation of Article 370, which provided for the special status to the erstwhile state of Jammu and Kashmir, now broken into union territories. So in 2019, the repeal of Article 370, it brought a very significant change to the structure of Jammu and Kashmir, legally speaking. Now, the Jammu and Kashmir Reorganization Act, this was enacted, as we all know, specifying which state laws would continue and repealing several other Indian laws. Now, I have a question, and I would absolutely appreciate those of you who could answer in the comment section. So what is the date from which the Jammu and Kashmir Reorganization Act of 2019, it came into force? This is a very potential, PD question for your judiciary exams, because we know how IPC, CRPC, all of these, statutes, they've been amended so far as their section 1 is concerned about their applicability to Jammu and Kashmir. So now let's talk about, what is the status of this law post 2019. So while the security law like the Enemy Agents Ordinance and Public Safety Act, it remained unchanged. But we know that laws like the Ranbir Penal Code equivalent to IPC, it was repealed by the Indian Penal Code. Additionally, there are certain laws like the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006, which is also called the Forest Act. Apart from that, we have the Scheduled Castes and the Scheduled Tribes Prevention of Atrocities Acts of 1989. These were also extended to apply in Jammu and Kashmir. Now let's talk about how trials are conducted in this particular law. Now please understand, here trials are very, very rigorous. Now we all know that so far as our criminal jurisprudence is concerned, we believe that every person is considered to be innocent until and unless he or she is proven guilty, correct? And it also important for our criminal law jurisprudence that the other person, the accused, is heard. He is given an opportunity to put forth his defense very transparently, correct? But here, interestingly, in this particular law, there is a very peculiar sort of a situation. So let's understand what is that. The trial under the Enemy Agents Ordinance, it is conducted by a special judge. Now, who is going to appoint the special judge? The special judge is appointed by the government in consultation with the High Court. So that's normal. There's no issue with it. Now, this is very interesting. Under this ordinance, the accused cannot engage a lawyer to defend herself or himself unless permitted by the court. So here, a very important principle of natural justice, that no one should be condemned before being heard, it is, to a certain extent deviated from. So here, in order for the accused to engage a counsel to put forth his or her defense, the permission of the court is needed. So according to the ordinance, in proceedings before a special judge or a reviewing judge as well, under section 9 of this ordinance, accused persons may be represented by a pleader if permission is granted for this purpose. Further, this ordinance does not allow for appeals against the verdict. So that's another, strictness that this law shows, which is that there is no provision for appeal against the verdict of the special judge. Instead, however, there is one relief, which is the remedy of review. Now, the review can be taken up by a judge who is chosen by the government from the High Court, and the decision of the judge so chosen is the final deciding authority. Now, this ordinance, it also bars any disclosure or publication of the case which is tried under it. This is more or less similar to, I believe, Article 19 or 20 of the POCSO Act as well. According to the ordinance, disclosing, or although in POCSO Act, the disclosure of identity, the bar on it, it is for the identity of the child. So here, according to the ordinance, disclosing or punishing or publishing information about the proceedings or about the individuals who are involved in the case without government authorization, this is punishable by up to 2 years of imprisonment or by fine or with both. Now, let's understand whether there have been instances whereby certain persons were tried under this ordinance. So there are scores of Kashmiris who are or have been tried and sentenced under this particular law. Jammu and Kashmir Liberation Front founder Makbul Bhatt, who was hanged in Tihar jail back in 1984, he was also charged under this ordinance. So I hope this serves your purpose and you're able to, reflect upon this particular law. You're able to understand its core. Now with this, we proceed to the national news category, and this is the first update. Srinagar gets tag of World Craft City. This is an important update. Students, please make note of it. So the capital city of Srinagar, it has been officially recognized by the World Crafts Council as the World Craft City, thereby highlighting the rich cultural heritage and the outstanding skills that the artisans of Srinagar, they have gained, they have the caliber of, and thereby it has now gotten a global recognition. Also, please understand, apart from Srinagar being Srinagar having gotten this tag for this year, we have Jaipur, Malappuram, and also Mysore as the other Indian cities that have previously been recognized with this particular tag. India secures Olympic team quotas in archery. India has secured both men's and women's team quotas in archery for the upcoming Olympic Games in Paris this year, based on the latest world rankings. India can now compete in all 5 medal categories at the Olympics, which is an event that happens every 4th year. In the men's section, both India and China have qualified, while in the women's section, Indonesia and India have qualified. From India's perspective, veteran Tarundeep Rai and former world #1 ranked Deepika Kumari will participate in their 4th Olympic Games. This is another important update. Intelligence Bureau Chief Tapan Kumar Deka, he gets 1 year extension of his tenure. Tapan Kumar Deka, he is a 1988 batch IPS officer. He has been given an extension as the IB, the Intelligence Bureau Chief, for another year, extending beyond 30th of June this year. He has served as the Joint Director Operations for the Intelligence Bureau and has handled Islamic extremism in India for the past 2 decades. Now, this is an interesting update. So the State Assembly for the state of Kerala, it passes a unanimous resolution to officially change its name. So this is a very important update. After the Union Home Ministry reviewed the first resolution and suggested some minor changes, the Kerala Legislative Assembly has now unanimously adopted a resolution urging the centre to officially change the state's name to Kerala. The Chief Minister for the state, Pinarayi Vijayan, he proposed renaming the state to Kerala under Article 3 of the Indian Constitution, highlighting its use in Malayalam and the historical demand for a unified Kerala for Malayalam-speaking communities since the freedom struggle. Now, here I have a question, and again, it would be absolutely amazing if you could answer the same in the comment section. So let's say there is a law which is passed for the purpose of Article 3 of the Indian Constitution for, amending the boundary of any state, changing the name of the state concerned. Then is it considered to be an amendment under Article 368 of the Indian Constitution? If your answer is, let's say, yes or no, then which article of the Indian Constitution provides for the same, whether it is an amendment under Article 368 or not? And now we proceed to the next update. Indian Army signs MOU for next generation wireless technologies. The Military College of Telecommunication Engineering and the Society for Applied Microwave Electronics Engineering and Research, which is an R&D, a research and development lab under the Ministry of Information Technology, it signed an MOU to enhance cooperation in developing next generation wireless technologies for the Indian Army. This initiative, it is a very important, a very significant step forward in boosting the Indian Army's technology capabilities. And this is in line with the Chief of Army Staff's vision for 2024 as the year of technological aspiration for the forces. Now, with this, we proceed to the international news segment, and this is yet another important update. UNGA President honors India's Hansa Mehta in International Day for Women in Diplomacy. The UN General Assembly, the United Nations General Assembly President, has paid tribute to Indian reformer and educator Hansa Mehta as he honored the women diplomats' invaluable contributions on International Day of Women in Diplomacy. Hansa Mehta, she represented India at the United Nations Commission on Human Rights back in 1947 to 1948. He's famous for advocating for gender-sensitive language in Universal Declaration of Human Rights, the UDHR. US designates Kenya as major non-NATO ally. The United States of America, the USA, it has designated Kenya as its major non-NATO ally. The MNNA status, it is a designation which is under the US law. It is given and it provides foreign partners with certain benefits in the areas of defense, trade, and security cooperation. So that is the kind of advantage, so to say, that you get once you are given this status. While the MNNA, its status, it offers military and economic benefits. It does not require any security obligations to the country that receives this designation. Now with this, we've come to the legal news segment for the day, and the first update is from Honorable High Court of Orissa. The Orissa or Odisha High Court, it is held that merely rejecting to marry a girl after getting engaged to her, per se, it would not amount to abetment of suicide as provided under Section 306 of the IPC. And there are certain elements of Section 306 of the IPC that have to be met. So merely because a guy refused to, let's say, marry a girl after having gotten engaged, per se, solely this factor alone, it would not amount to abetment of suicide. That was the verdict of the High Court of Orissa. So the name of this particular case is Dr. Priyank Tapuria versus the state of Orissa and others. Now, next update is from the Honorable Supreme Court. So the Supreme Court has dismissed a petition which was filed by a judicial officer seeking promotion to a vacancy which arose after the elevation of a district judge to the High Court. Now, refusing to interfere with the judgment of the Himachal Pradesh High Court, the Apex Court observed that a vacancy which is arising out of the elevation of a judge, it could never be termed as an anticipated vacancy. So next update is from Honorable High Court of Bombay. So the Bombay High Court orders release of minor who is accused in the Pune accident case that saw, in fact, I would say that enraged the entire nation. So the Bombay High Court has ordered the release of the minor who is accused of the Pune Porsche accident case into the care and custody of his parental aunt. A division bench of the Honorable High Court, it granted the release of a minor accused currently in an observation home in response to a habeas corpus petition which was filed by his paternal aunt. I'm sorry. So the custody is released into custody of his paternal aunt. The court declared the impugned remand orders passed by the Juvenile Justice Board illegal and without jurisdiction. The court has directed that the counseling sessions with the psychologists, which were ordered by the JJB, which is the Juvenile Justice Board, it should continue even after the minor's release. In a recent hearing, the court questioned the Juvenile Justice Board's decision to remand the minor accused in this particular car accident to an observation home despite being on bail, stating that this action, it effectively negated the purpose of bail. The bench questioned the authority to remand a juvenile to an observation home after bail has been granted to him, saying that this thereby negates the entire purpose of being enlarged or released on bail. It noted that concerns about mob lynching prevented the minor from attending court-ordered counseling sessions. The incident occurred back on 19th of May 2024, this year, involving the 17-year-old who is son of a prominent Pune builder who allegedly drove a very luxury car while intoxicated, causing a fatal collision in an area of Pune, which led to the loss of lives of 2 youngsters. Moving on to the next update. Give me just a moment. My screen has frozen. All right, so that's about the TNA that we have for the day. Thank you so much for watching. And please don't forget to put your answers in the comment section. Have a wonderful day ahead.